Okay. Well, I think I'll go ahead and get started. For those of you that just joined, one thing I went over at the start, when we're finished here today, Erin from my office is just going to be circulating an email to get the full attendance, and we'll be circulating a survey that has to be filled out in order to get the CLE and CE credits. So just be on the lookout for that, probably shortly after the presentation. So as I mentioned, we're going to be talking about emerging trends in employment law over the past couple of years here this afternoon. I think this is going to be about an hour-long presentation, so we should wrap up by about 1 o'clock Eastern time. And the first topic I wanted to talk about was federal legislation that was recently passed relating to arbitration of sexual harassment and sexual assault claims. And this is a product of sort of the Me Too era. This is the first major piece of federal legislation that came out of that movement. And it was signed into law by President Biden in March of this past year. And essentially, there was a lot of concern about forced arbitration clauses that our employers use at the outset of the employment relationship when someone's hired. They oftentimes will have employees sign agreements that waive their ability to participate in class or collective action lawsuits or to bring any claims before a jury. And basically, I cited on the PowerPoint to some of the legislative history that talked about the concerns that these forced arbitration clauses have raised with Congress. But a lot of times it is in the form of a take it or leave it contract by two participants that have very different power dynamics, usually a large company and an individual who oftentimes doesn't really know what they're agreeing to at the time that they sign these agreements. And just looking at some of this legislative history, it was projected, or it is projected, that by 2024, approximately 80% of private sector workers would be forced to sign some type of arbitration clause that would waive their ability to bring a claim before a jury if there was some ultimate dispute between that individual and their employer. So what it's called the EFA, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. And I've cited too in the PowerPoint some definitions under that act, but a pre-dispute arbitration agreement is basically any agreement that an employer enters into with an employee prior to the time that there's been any dispute between them that has arisen. And then similarly, a pre-dispute joint action waiver is when an individual waives the ability to bring a class or collective action before any dispute has arisen. And there's also definitions for sexual assault disputes as well as sexual harassment disputes under the ERA. And essentially what the ERA does is it says that any pre-dispute arbitration clauses that attempts to limit an individual's ability to bring a sexual assault claim or a sexual harassment claim to a jury is void. And the same thing with any agreements that attempt to bar an employee from bringing a class or class action sexual assault or sexual harassment claim. And the EFA applies to pre-dispute agreements. So it is possible if after a dispute has arisen for an employer to enter into an agreement with an employee where they waive their right to a jury trial based on a sexual harassment or sexual assault claim, and the individual agrees to arbitrate the matter. But anything pre-dispute, so at the outset of the employment relationship, is void under the ERA. And there are a few exceptions. It does not apply to employment contracts for transportation workers. And parties can contract out of the FAA by choosing different rules to govern the arbitration. But the Act and the amendments apply with respect to any dispute or claim that arises or accrues on or after the enactment of the Act. And as I stated, that went into effect this past March. Now, there's some serious questions about exactly how this is going to be applied. And as part of this PowerPoint presentation, I've cited to some of the legislative materials where you can see the comments of different senators from different sides of the aisle that have different views of how this ultimately would be interpreted. And, you know, if you look at this slide, it's a quote from Senator Joni Ernst of Iowa saying that the bill should not be the catalyst for destroying pre-dispute arbitration agreements in all employment matters, and that the bill text would not require any court to adopt new dismissal mechanisms for survivors' claims. So really the big question that's sort of unresolved about how this is going to be interpreted is, you know, if there is a claim that involves both, you know, allegations of sexual assault or sexual harassment, as well as other types of claims, you know, what happens if the sexual assault, sexual harassment claim is ultimately dismissed? Would that mean that at that point, you know, if there are other claims that are validly waived by an arbitration agreement, they would get kicked out of court and sent to an arbitration? You know, and looking at the legislative history, according to the you know, Democratic supporters of this, it states that the bill should not be interpreted to require that if a sexual assault or harassment claim is brought forward in conjunction with another claim and that's later dismissed, that the court would remand it. But there's a lot of uncertainty as to how that is actually going to happen in effect once these claims are litigated. And again, this is, you know, what are related claims? And if there's a pre-dispute arbitration clause and a sexual assault or harassment claim is brought forward with another employment claim that's later dismissed, you know, at least the Republican sentiment at the time of this passage was that the court should remand the other claim back for an arbitration. There are similar statutes that have been passed in different states that actually have broader application than the EFA. As I stated before, the EFA really only applies to arbitration clauses in claims of sexual assault or sexual harassment. But as you can see here, New York has passed a statute, as well as New Jersey, that basically says any clause or provision in any contract which requires as a condition of the enforcement of the contract or obtaining remedies under the contract that the parties submit to mandatory arbitration to resolve any allegation or claim of discrimination in violation of laws prohibiting discrimination. So that's obviously broader. It's not just sexual harassment. The New York law also bans forced arbitration, pre-dispute arbitration clauses in discrimination claims. New Jersey has similar language. It prohibits pre-dispute arbitration, mandatory arbitration clauses for claims of discrimination, retaliation, or harassment. In terms of federal legislation, there has been proposed legislation passed in the House of Representatives called the Forced Arbitration and Justice Repeal Act of 2022 that would expand this ban on pre-dispute arbitration, mandatory arbitration clauses, to not just include sexual assault and sexual harassment claims, but to also preclude these types of clauses in any employment dispute, consumer dispute, antitrust dispute, or civil rights dispute. So that has stalled in the Senate. It has not been passed into law, but obviously if something like that were passed, it would have very major implications for employers in terms of being able to pre-dispute, force individuals to arbitrate employment-related claims. So something to look at if, after the midterm elections, if there were more Democrats in the Senate, that's something that could potentially pass and would have very major implications on employment law throughout the country. The next topic that I was going to talk about was issues relating to virtual employees that obviously has come up quite a bit with all of the remote work that's been occurring since the pandemic. And this environment has made things obviously very difficult and challenging for employers in really all types of industries. And there are a number of issues that all kinds of employers have to consider in light of the fact that most employers, I would say, still have a good portion of their workforce that is working remotely. And this slide just lists a number of the items that employers need to consider to make sure that they're in compliance with, in this new environment. And, obviously you could have a small business that was pre-pandemic. All the employees were reporting to the same office in the same locality. Now with remote work, you can have employees working really across the country. And that leads to having employers have to consider what state business registrations they have to undertake. They have to, in most instances, register to do business in any state where they have an employee working from. There are also can be very significant differences in the state and federal wage and hour laws that will go into effect depending on where employees are working. And there can also be very significant differences in state and federal employment and anti-discrimination laws. And as an example, the majority of locations have, some type of limit. Their anti-discrimination statutes have some type of limit on the number of employees that an employer has to have in order for that anti-discrimination statute to apply. So, under federal law, a lot of them, you have to have a minimum of 15 employees for the anti-discrimination statute to apply. DC's Human Rights Act, which is one of the most employee-friendly human rights act in the country, any employer that has one or more employees is subject to the DC Human Rights Act. So you could have a small employer working in a state that has a human rights statute with a minimum of 15 employees. If they have an individual working remotely from DC, they're potentially going to be subject to the DC Human Rights Act, regardless of their size. So issues like that are things that employers need to be aware of, and they really have to keep track of where everyone that's employed with them are working from and make sure they're in compliance with the laws of that locality. That also applies to state and federal benefits, such as the FMLA and paid leave. A lot of states can have very significant differences with respect to benefits. It can have an impact on workers' compensation issues, as well as the notices and posting requirements that employers have to provide to their employees. And this has become, we do a lot of work with helping employers prepare their employee handbooks. And this has created a real challenge in what has to be included in employee handbooks when all of a sudden a lot of employers now have individuals working in locations where they were never working before. And it can create confusion and add to the amount of information that frankly has to be included in an employee handbook to make sure that it is including information related to all localities where the employer actually has employees working. One of the first items we talked about was the registration requirement, and most states are going to have a requirement that if an employer has an employee working in that state, that the company has to register to do business in that state. And as a corollary to that, in most instances, the employer is also going to have to register with that state's tax authority. And taxes are going to be determined by the state where the employee is working, so that there would have to be withholdings from that state for taxes. And when a business registers to in a foreign state or a state where they hadn't been registered before, that can have a number of different implications. As I mentioned before, it can require adherence to the state's wage and hour laws, their anti-discrimination laws, their benefit laws, and workers' compensation laws. And it can result in very different liability exposure for the employer. And, going back again to the example of the anti-discrimination statutes, a lot of anti-discrimination statutes have very different exposure that an employer can be subjected to depending on which statute applies. So again, using DC as an example, supervisors can have individual liability under the DC Human Rights Act. The DC Human Rights Act has no cap on emotional distress or punitive damages, where unlike the federal anti-discrimination statutes that have caps based on the number of employees that an employer has. And the federal statutes also do not have individual supervisor liability, and most jurisdictions, I would say, do not have that. But again, if you have an employer who has an employee that is now working in a jurisdiction that has a very employee-friendly Human Rights Act or anti-discrimination statute, it's something that employers need to be aware of. A Supreme Court case that's going to be taken up in the next term could have very significant impacts on this issue of companies now registering to do business any place where an employee is working. And that's the Mallory versus Norfolk Southern Railway case. It hasn't been decided, but the case involves basically a Pennsylvania statute that states that if a company registers to do business in Pennsylvania, they consent to personal jurisdiction in that state. So that was a situation where an individual who was actually not employed in Pennsylvania sued a company that was not based in Pennsylvania in Philadelphia, just because it was what was viewed as a plaintiff-friendly venue. And under Pennsylvania statute, because this company was registered to do business in Pennsylvania, the plaintiff argued they subjected themselves to personal jurisdiction in state court in Pennsylvania. Now, the Supreme Court is going to decide whether or not that is constitutional under the Due Process Clause. And if there is a ruling that statutes such as that are constitutional, again, that's going to have very wide-reaching implications, because it's basically going to say that an employer can get sued anywhere in state court where it has registered to do business. Workers' compensation issues also create some unique challenges in the remote working environment. And this slide just cites to the federal rule that basically says injuries and illnesses that occur while an employee is working at home, including work in a home office, are still considered work-related injuries or illnesses that trigger workers' compensation policies. And so that sort of places burdens on employers to make sure that if they have employees who are working remotely in home offices, that steps are being taken to make sure that they're working in a safe environment. And items for employers to consider are, whether the employee is designating a work area and certifies that it has basic safety measures in place while conducting work at home. Now, in practice, it may be sort of difficult to certify this, but just documenting that there has been an attempt made to do so can help an employer if one of these issues arises. Employers should require that any employees who are working remotely report all injuries and illnesses that occur while they're performing work functions. And it's worth considering prohibiting employees who are working remotely from hosting clients or coworkers or any other third parties that could theoretically impose liability on the employer if some type of injury or were to occur. And again, different states are going to have slightly different workers' compensation laws. So the law of the venue where the employee is at the time is what's going to control. Other issues that really have changed with the virtual working environment are wage and hour issues under both the Fair Labor Standards Act, the federal statute, as well as state wage and hour laws. And one of the biggest concerns is if you have a non-exempt employee that is entitled to overtime if they're working more than 40 hours a week, how do you track that, and how do you make sure as an employer that you're complying with those overtime laws? And making sure that employers are accurately tracking the time being worked by employees is crucial, particularly when people aren't all in the same place, aren't working in the office, and you don't necessarily know when someone is starting to work, when they're ending their day, what they're doing throughout the day. And a person can be entitled to overtime compensation if they're a non-exempt employee, even if they're performing tasks, before or after work or during scheduled breaks. And an example is obviously reviewing and responding to emails or text messages or participating in virtual meetings. That's all happening so much more now in this virtual environment. But if you have non-exempt employees that are required to either respond to or expected to respond to emails, expected to take calls or participate in virtual meetings after hours, that could trigger overtime requirements, and it could trigger the employer to have to pay time and a half for times that those individuals are working. The Department of Labor recently issued guidance that emphasized the importance of employers scheduling work hours. if an employee is taking breaks for whatever reason, including childcare, the employer is not obligated to compensate them for those breaks. But if they are doing work during any of those breaks, then potentially they do have to. So, documentation on this is critically important to make sure that there are set hours in place for non-exempt employees, and make sure that they are sticking to those set hours and not working times when they're not supposed to be working. We anticipate that because of these issues with remote working, that there will be a significant increase in wage and hour litigation. And as I said, that's why implementing timekeeping methods that apply to everyone, that everyone is adhering to, is going to be critical. And I cited there to a wage and hour division field bulletin that states an employer should provide a reasonable reporting procedure for non-scheduled time and compensate employees for all reported hours of work, even hours not requested by the employer. So again, documentation is the key. The more employers document the hours that are supposed to be worked and the hours that actually are being worked by employees, the better they're going to be able to defend against wage and hour claims. Other issues to be aware of with remote work, bring your own device policies. There's a lot of blurred lines nowadays between work and personal cell phones, computers, tablets, what have you. And the survey cited in this slide says that there are 36.2 million Americans who are expected to be working remotely by the year 2025. And that creates a lot of potential problems with employer bring your own device policies in terms of liability, who owns the devices, who owns the data contained on the devices, and so forth. And we cited here to what's called the Cyber Incident Reporting for Critical Infrastructure Act. That was passed in 2022, and it requires owners and operators of critical infrastructure to report cyber incidents within 72 hours. So if you do have an employer who is somehow involved with critical infrastructure, even if their employees are working remotely, they may have obligations to report cyber incidents, and they could have liability issues if they don't under federal law. And the cyber concerns and the potential for hacking when people are working remotely has obviously increased substantially, and that can lead to potential liability for employers. And as I cited in this slide, bring your own device policies can actually impact a corporate party's discovery obligations. And we cited to the In re Pork antitrust litigation. That was a lawsuit brought by the Department of Justice against a number of meat manufacturers alleging price fixing. And there were significant discovery disputes that arose relating to whether or not executives within some of these companies who had both work and personal data saved on their personal cell phones had to comply with subpoenas during discovery. And the court ultimately found that when there are blurred lines on that, when someone has both personal and work information on a device, that they subject themselves to discovery obligations. So in that case, the arguably personal cell phones of several executives were actually imaged and looked at as part of the discovery process. Other issues that can arise from remote working, childcare issues have become a fairly common topic. and generally speaking, telework is not a substitute for childcare. Employers are within their rights to tell employees that, and we advise most of our clients in their employee handbooks to have some type of provision that expressly lays that out. And the language we included here: teleworking is not a substitute for childcare, and employees who are permitted to telecommute must make appropriate arrangements for childcare needs during working hours. And um, employers, it would be, I think, well advised to make sure that they do have those policies in place and make sure that their employees are actually adhering to those types of policies. So steps employers should take in this environment. Employment policies are very important, and with a lot of the changes that have occurred over the past 2.5 years, I think most employers would be well suited to take a look at their employment policies to see if they're outdated at this point, given all the changes in the workplace. They need to ensure that they're complying with the EEO and sexual harassment policies, even if their employees are working remotely, and remind employees that those policies are still in place regardless of where they are working from. And, there's some concern that with a more casual environment, with people not, being in person in the office, that more issues could arise. In some ways, there are less issues with people not being together, but there is a concern with Zoom meetings and a more casual environment that other issues can come up. Employees still need to be aware of how to report concerns of discrimination or harassment, even if they're not reporting to work in person. And employers need to make sure that those policies are clearly delineated to their employees. Another issue that employers should be aware of: not only could employment policies be outdated just with the shift to virtual, but job descriptions for employees could now be outdated. And those should be reviewed, and to the extent that there are significant changes to an individual's job description as a result of teleworking, then that should be taken into account. It is important for employers to continue to document performance issues, and that's something that can sort of fall by the wayside to some degree when people aren't working together. But obviously, employment issues can still arise, and it's still important that things are documented, even if people aren't in the same place. And in terms of onboarding, team building, things of that nature, they still need to be conducted in some way. Employment policies still have to be disseminated to employees, and there still has to be training implemented for employees to make sure that state and local anti-discrimination laws are adhered to. Shifting gears, I'm going to talk now about some legal issues that can arise in the employment context with employers mandating or requiring employees to return to the workplace. And I know I'm sure a number of you have dealt with various claims dealing with this issue. It's definitely, I would say, a topic that's dying down a little bit more in more recent months with the pandemic sort of leveling out, but something that we're still seeing, and I think certainly will still be a topic for the foreseeable future. Looking at impacts of employers mandating employee returns to the workplace. Safety concerns are something that employers need to be aware of, making sure that they're in compliance with applicable, EEOC guidelines, as well as CDC guidelines and OSHA guidelines, which govern workplace safety. In terms of vaccine mandates, there's been a lot of litigation and there's been a lot of news coverage of vaccine mandates, and obviously it's been a contentious issue. But looking at how the EEOC views it, in December of 2020, the EEOC issued guidance, indicating that employers are lawfully permitted to require employees to be vaccinated before returning to the office, but subject to limitation and exceptions under both Title VII of the Civil Rights Act of 1964, as well as the Americans with Disabilities Act. And what that essentially says is that you can't just automatically have a blanket vaccine mandate if someone raises a concern under either the ADA or a religious request for accommodation. The employer has certain obligations to consider those employee requests. And looking particularly at the Americans with Disabilities Act, the ADA, there are limitations in terms of what an employer can discuss with an employee about their health condition. The EEOC has issued guidance that basically state that an individual receiving a vaccine or requiring an employee to show proof of a vaccine is not a medical examination or disability-related inquiry that's prohibited under the ADA. So, an employer can ask if someone has been vaccinated or make them show proof of vaccination. But there are potential exceptions to that can create potential problems for employers. Information that's obtained during the vaccination process can theoretically trigger these medical examination or disability-related inquiries that are prohibited under the ADA. And also, notice of a disability can trigger obligations that the employer, in what's called engage in the interactive process with the employee and discuss with them, potential reasonable accommodations that can be put in place as an alternative to a vaccine mandate. So under current CDC guidance, healthcare providers who administer vaccines are encouraged to ask questions about the health condition of the individual before administering the vaccine. And that's to ensure that there are no medical limitations where where it wouldn't be a good idea for the person to be vaccinated, where the person could have adverse health outcomes as a result of the vaccination. And if an employer or a third party contracted by an employer, asks an individual about, pre-vaccination information, that could constitute a disability-related inquiry that runs afoul of the ADA. So under the ADA, if an employer is asking specific questions about, for example, why an individual is not vaccinated, any inquiry like that has to be job related and consistent with business necessity. And that's a term of art under the ADA, where there's a lot of case law that discusses what goes into that. But the EEOC, under recent guidance, has cautioned that pre-vaccination questions should be careful to avoid questions about an individual's family, medical, or genetic history that would implicate the Genetic Information Non-Discrimination Act. In terms of what employers can do to make sure that they're providing a safe workplace for the employees, but also limiting liability for potential claims from employees that do not want to get vaccinated. The exposure related to employer mandated vaccines is minimized, although not completely eliminated, if the employer simply requires proof of vaccination and doesn't get into any further inquiries about the health condition of the individual. Employer should not have access to any medical information that comes out as part of an individual's pre-vaccine screening. But subsequent employer questions like asking, why an individual did not receive a vaccination, that can create potential problems for an employer, as I mentioned before. Employers also should, if they're engaging in this interactive process and looking at, potentially providing an accommodation for a non-vaccinated employee, they should be looking at the type of position that the individual is working for to see if there's a legitimate business reason to require the vaccination. So, if you have a back office staff person who really doesn't have interaction with anyone else throughout the day, could they be accommodated? Could there be a basis for allowing them to come into the office even if they're not vaccinated? And that, is a distinctly different situation than an individual that is around a number of people and has direct contact with, outside customers or clients. The EEOC has made it clear that an employer may not automatically exclude an employee from the workplace for refusing or being ineligible for vaccines. And I don't think there's anyone that's really ineligible anymore. But the EEOC says that an employer has to show that an unvaccinated employee would pose a direct threat due to a significant risk of substantial harm to the health or safety of the individual that cannot be eliminated or reduced by reasonable accommodation. So this actually does place quite a burden on employers to engage with employees. So just a blanket across the board. If you are not vaccinated, you cannot come to work without having a basis for it that is thought out. It is going to create problems potentially with liability for employers. In addition to that, the EEOC provides further guidance that employers should conduct an individualized assessment of 4 different factors, and it's the duration of the risk, the nature and severity of the potential harm, the likelihood that potential harm will occur, and the imminence of the potential harm. And again, this is quite burdensome for employers to actually go through these types of assessments, particularly large employers that could have a number of employees requesting accommodations for vaccine mandates. A conclusion by an employer that there is a direct threat would have to include a determination that an unvaccinated individual will potentially expose others to the virus at the work site. And that also takes into account the number of other employees that are fully vaccinated. So, the more that are fully vaccinated, the less potential risk there is for the employer. If an employer does determine that an unvaccinated employee poses a direct threat, the EEOC still cautions that the employer should not exclude that employee from the workplace unless there's no way to provide a reasonable accommodation absent undue hardship. that would eliminate or reduce this risk so that the unvaccinated employee does not pose a direct threat. And then even when considering whether there is an undue hardship, the EEOC guidance notes that prevalence in the workplace of employees who already have received a COVID vaccination and the amount of contact with others whose vaccination status could be unknown is also a factor to be considered. So what I would say is the more time that goes by and the more that the COVID is really just ingrained in society, more and more people that have contracted it, the harder it's going to be for employers to meet these burdens and demonstrate that, vaccine mandates that requiring them are viable without providing accommodations to unvaccinated employees. And again, if there's no reasonable accommodation absent undue hardship that would eliminate or reduce the risk posed by an unvaccinated employee, the employer can exclude the employee from entering the workplace. So that, as we've looked at all the guidance the EEOC has issued on this, that's a pretty high standard for employers to meet. And in addition to accommodation requests for vaccine exemptions for health-related conditions, a common issue that has arisen over the past year or so is religious accommodation requests by employees. And Title VII of the Federal Civil Rights Act of 1964 requires employers to provide reasonable accommodations to employees who indicate they cannot receive the vaccine because of a sincerely held religious belief, practice, or observance, unless accommodation would pose an undue hardship. And the EEOC guidance, again, puts a lot of burdens on employers on this because it says that an employer should ordinarily assume that an employee's request for a religious accommodation is based on a sincerely held religious belief. And this does not have to include, widely recognized religions. So it can be really anything that a person claims to be a religious belief if it is sincerely held. And obviously, getting to the bottom of what a sincerely held religious belief is for an individual is a very fact-specific inquiry, and challenging someone on whether or not a religious belief that they claim to hold is sincere is something that is going to be difficult for an employer to do. Despite that, employers they can be justified in requesting additional supporting information if they do have doubts or have questions about the religious nature or sincerity of an individual's belief. But similar to the ADA, this is an individualized fact-based assessment that an employer has to go through. They can't just have a blanket restriction. They would have to have a conversation with the individual, get to the bottom of what their belief is, and see if there's any way that it can be accommodated without causing an undue hardship on the employer. And if there is no reasonable accommodation absent an undue hardship, the employer can at that point exclude the individual from entering the workplace. So just kind of overarching themes of returning employees to the workplace after the pandemic. Accommodations are something that always have to be considered by an employer. If If they don't, and they have rigid return to work guidance in place, it's going to potentially lead to liability concerns for the employer. Things that employers can look at is standard industry practice, depending on the nature of the business. What are most businesses that are similarly situated doing? Complying with CDC guidance can be a way to minimize risk. And another thing that employers have to keep in mind is the impact of any policies that they have on recruitment and retention. And obviously, we've all heard a lot over the past few years of how tight this labor market is, how difficult it is to find individuals to fill roles at businesses. So, a very rigid return to work policy for employers is oftentimes going to lead to retention and recruitment problems. That may be changing over time. You are seeing more and more employers, large and small, issuing mandates requiring people to come back to work at least at some level. But in terms of not allowing any telework at all, that's going to be difficult for recruitment for employers. Other things that employers should keep in mind with employees returning to work, making sure that, and this goes to sort of the OSHA regulations about workplace safety that we talked about, but making sure that there's a provision of PPE and other sanitizing efforts. Physical distancing, that's become less and less of an issue, I'd say, over time. But in certain instances, depending on the state and local rules, that could still come into play if there are additional outbreaks or surges. Rotating in office shifts. A lot of employers have been trying that. Half the staff in one week, half the staff in another week. Those are things that could be taken into account. And with the, sort of as we talked about before, with the prevalence of remote work and the number of employers that allowed remote work for a substantial period of time as a result of the pandemic, it's going to be more and more difficult for employers to establish that allowing an individual to work remotely as an accommodation for either a religious exemption or a health exemption under the ADA would create any type of undue hardship. Other items that employers should consider for employees returning to work, implementing procedures for contact tracing. Again, that's something that I would say is not as vital as maybe it was a year ago when the strains of the virus were still very prevalent and surging. But also, employers should review their policies to ensure that they're complying with any newly enacted federal, state, or local leave policies that have resulted from the pandemic. So those are just some issues about the return to work. So we're up on an hour. I am not going to get through this entire PowerPoint presentation. I'm happy to circulate it to everyone when we're done if anyone wants to take a look at it. But I did want to give folks an opportunity to ask any questions if there's anyone that has any questions before we wrap up here this afternoon. Okay. Well, I will take that as there being no questions. If anything does come up that anyone has any questions about, you can feel free to email me or Aaron. As I said, Aaron will be circulating an email probably this afternoon or definitely by tomorrow, just getting the full the full attendee list and also submitting a survey that people can fill out so you can get the CLE and CE credit. So I appreciate everyone's time, and have a great afternoon, everyone.